Welcome. We are opening up a really substantial stack of sources today. We're going to be exploring a case that I think stands as one of the most complex, tragic, and ethically challenging chapters in American criminal justice history.
It really is. And this isn't, a simple narrative of a man being freed from death row. It's so much more complicated than that.
Right. It's a story about that perilous line between dedicated advocacy and due process. It really asks the question of what happens when the desire for justice becomes so urgent, so overwhelming, that it actually creates a new injustice entirely.
That is the essential conflict at the heart of all the material we've gathered here. We're examining the Anthony Porter case. This was a man who endured 17 years waiting for execution in Illinois for a double murder that it turns out he absolutely did not commit.
And his eventual release set off this incredible chain reaction. It ultimately contributed to the abolition of the death penalty in that state.
It did. But, and this is the crucial but, the methods that were used to secure his freedom led directly and tragically to the wrongful conviction of another man, All-Story Simon.
It's just a story of constant contradiction.
Before we get into analyzing the legal and, frankly, the ethical maze here, we have to pause. We must acknowledge the devastating reality that set this entire timeline in motion.
Of course.
Our sources take us back to the south side of Chicago. The date is August 15th, 1982. This is the moment when the lives of Marilyn Green and her fiancé, Jerry Hillard, were brutally cut short.
They were shot and killed. It happened near a swimming pool in Washington Park.
And we just want to say that we hold profound sympathy for the victims and for their families. Their initial and their lasting tragedy is so often overshadowed by all the legal controversies that followed.
Indeed. And what makes this examination of the source material so critical is that Green and Hillard's murders, even today, remain officially unresolved.
That's the real bottom line here. Right. So our mission here today is to really dissect the documents, the testimony, the investigative reports, all the sources detailing Anthony Porter's original conviction, then the highly contested efforts by the Northwestern University Innocence Project to secure his release, and then the subsequent catastrophic fallout that followed.
And it leaves us with this deeply scarred legal landscape and, as you said, an open double homicide file.
Exactly.
Okay, let's unpack this. It is a monumental legal failure from start to finish. We'll begin at the very start with part one, the original conviction and near execution. How did the system go so terribly wrong the first time around?
Well, the initial investigation, according to all the sources we have, it was really characterized by speed. And what, looking back, appears to be a pretty severe case of tunnel vision.
Tunnel vision.
Yeah.
So they zeroed in on someone fast.
Very fast. Anthony Porter, who was a 27-year-old man known to be affiliated with a gang in the area, he was identified almost immediately.
And you have to imagine the context, right? High crime, a lot of pressure on law enforcement to get a result.
Absolutely. They seemed determined to find a swift resolution.
And from that, the prosecution quickly built what, at least on the surface, appeared to be a pretty strong case.
It did. We're talking about 6 witnesses who initially placed Porter near the shooting or claimed to have some knowledge of his involvement.
So this wasn't just a fragile single eyewitness ID situation.
Yeah, no, not at all. It was a whole cluster of testimony that all seemed to point directly at Porter.
But when you start to dig into the details of those statements, the whole foundation of the case gets pretty shaky, doesn't it?
It really does. The prosecution's case leaned very, very heavily on 2 key pieces of testimony. The first of these involved a man named William Taylor.
Okay, William Taylor. Who was he?
Taylor was allegedly at the Washington Park pool swimming when the fatal shots were fired. And what's so critical here is that his story, it evolved dramatically under police questioning.
Tell us about that evolution. What did Taylor originally say, and how did his story change to become the thing that cemented the case against Porter?
Well, at first, Taylor stated that he saw nothing. Absolutely nothing related to the shooting. 0 involvement, 0 details to offer.
Okay, a bystander who didn't see anything.
Right. But later, the police obtained a new statement from him. And in this one, he explicitly claimed that he saw Anthony Porter firing the shots.
Wow. That is a huge shift.
It's the classic critical shift from a key witness, from being a bystander to a direct accuser. It's something that often happens under intensive police pressure, though, of course, the police at the time denied any wrongdoing.
So you have his direct accusation, and that combined with the other significant piece of corroborating evidence created the narrative they needed.
Yeah.
And that second piece was the armed robbery claim. Is that correct?
That's exactly right. Another witness came forward and claimed that Porter had robbed him at gunpoint just shortly before the double murder occurred in the park.
And that detail would have been essential for the prosecution.
Oh, absolutely. It did a few things. It established Porter's presence at the scene, it showed he had a firearm, and it painted this picture of a motive consistent with escalating violence. It made him look like this predatory figure out in the park on the night in question.
Now, Porter, when he heard that he was under suspicion, he actually turned himself in. That's a detail that often gets overlooked, I think.
It does. He went to the police, and you have to assume he believed he could clear his name.
But that's not what happened.
No. He was immediately arrested and charged with a whole long list of serious felonies. The 2 murders, armed robbery, unlawful restraint, and unlawful use of weapons. The trial that followed was, by all accounts, notably brief.
And the outcome was devastatingly swift.
It was.
And the judge, a man named Robert L. Skladowski, he left absolutely no doubt about the severity of the sentence.
No, he used exceptionally harsh language. The sources quote him as calling Porter a perverse shark.
A perverse shark. That judicial attitude, especially in 1980s Cook County, it just underscores the environment where these convictions were being handed down. It was one of absolute certainty and severity.
And that certainty was echoed in the appellate process that followed. The Illinois Supreme Court denied his initial appeal in 1986.
And the U.S. Supreme Court.
They followed suit. They denied his petition in 1987, so for all intents and purposes, the system had officially and repeatedly affirmed his guilt. For years after that, Porter's legal challenges became more and more routine, just focused on delaying the inevitable.
This is where the story shifts, though. It goes from a simple failed appeal to a genuine life-saving intervention. But it's one that took far, far too long. He'd been on death row for over a decade at this point.
Over a decade, yes.
So what happened in 1995 that changed everything?
In 1995, years into his confinement, a new defense counsel arranged for something that hadn't been done before: testing of Porter's mental capacity.
Yeah.
This was, and is, an essential step in capital defense cases, because intellectual disability really complicates the legal process.
And the discovery they made was, well, it was profound. Shocking, even, given the stakes.
Absolutely. The testing revealed that Anthony Porter had an IQ of 51.
51.
51. I mean, this is well below the threshold that legally characterizes intellectual disability. What this meant, legally speaking, was that a man who had been condemned to death was potentially incapable of even understanding the fundamental reasons for his punishment.
So this finding radically altered the constitutional landscape of his case. The argument was no longer just about whether he committed the crime, but whether the state could legally execute someone who lacked the capacity to grasp the concept of capital punishment itself.
Precisely. And while the Supreme Court hadn't yet issued its definitive ruling on executing the intellectually disabled, that would come later in the Atkins decision in 2002, the legal community understood this as an incredibly powerful mitigating factor.
So the new appeal was based on this.
Yes. The new appeal argued that Porter's severe intellectual disability rendered him incapable of comprehending his punishment, and that executing him would therefore violate the Eighth Amendment's prohibition against cruel and unusual punishment.
The sources, when you read them, they really convey this palpable sense of urgency around this appeal, because the clock was genuinely, literally, ticking down.
It was. His execution was scheduled for late 1998. The appeal, the stay of execution, was granted just 48 hours, some sources say it was exactly 50 hours, before he was due to receive the lethal injection.
Just 2 days away from being executed.
2 days. And this pause, it's critical to remember, it was triggered not by a finding of innocence, but by a finding of incompetence. That stay saved his life, and it inadvertently provided the necessary window, the crucial time, for investigative journalists to step in.
It's just incredible to think about. The entire trajectory of this case, and frankly the future of the death penalty in Illinois, hinged on a 2-day window enabled by an IQ score that had been missed for 17 years.
It's staggering.
That fragile pause sets the stage for what comes next. Part 2. The controversial intervention.
And this is where the Northwestern University Innocence Project enters the narrative. The dynamic of justice completely shifts here from, legal defense to investigative journalism.
The Porter case was taken on as a class assignment, right, for students in a journalism course.
That's right. It was led by Professor David Protess at the Medill School of Journalism.
And the mission was clear: challenge the judicial system's conviction. These students weren't just writing papers about this. They were actively out there digging for evidence, trying to expose what they believed were serious flaws in the original prosecution.
Which is, as you can imagine, a very unusual and often debated role for journalism students to take on. They were acting almost as a secondary defense team.
That dual role, being an advocate and a reporter, that's central to the ethical questions that later came to haunt this entire operation, isn't it?
It's the core of the problem. Their investigation, however, secured a monumental result almost immediately. They focused their efforts on that key eyewitness, William Taylor.
Okay, so they went back to him.
Yes. A student named Tom McCann and a private investigator, Paul J. Cellino, they located Taylor in December of 1998.
And the timing of this is crucial. It's right after Porter got his execution stay. So what exactly did Taylor tell them that managed to overturn 17 years of legal certainty?
Taylor provided a complete and utterly devastating recantation of his original identification. He stated unequivocally that he had lied back in 1982 when he accused Porter.
He admitted to lying. And his reason?
His reasoning was just as damning. He claimed that the Chicago police had, and this is his words, threatened, harassed, and intimidated him into naming Porter as the shooter.
So that suggests severe systemic police misconduct right at the foundation of the original conviction.
It does. It's an explosive piece of information. It implies that the core evidence that sent Porter to death row was manufactured through coercion by law enforcement. But, and here is the critical investigative detail that critics seized upon later, a detail that the sources really highlight as being problematic.
What's that?
The Innocence Project team did not systematically review the rest of the original evidence.
So they got what they needed from Taylor and stopped there.
That's a crucial insight. It really speaks to the distinction between advocacy and exhaustive investigation. McCann and Cellino, they secured the recantation from the most damaging witness, Taylor. But the sources confirmed they did not interview the other 5 original witnesses who had placed Porter near the scene.
Nor the detectives involved.
Nor did they interview the detectives from the 1982 case to hear their side of the story regarding Taylor's coercion claim.
In any kind of systematic investigation, especially one meant to overturn a death sentence, you would think you'd need to address every single piece of evidence, not just the linchpin testimony.
You would. Focusing solely on Taylor's recantation shows a really clear objective: to dismantle the existing verdict. And perhaps it was at the expense of a complete, balanced reinvestigation. This lack of a holistic review became a huge point of criticism when their own methods eventually came under scrutiny.
Right. But at the time, that flaw didn't matter. The investigative momentum was unstoppable.
It was, and the team rapidly pivoted to identifying who actually committed the crime. They believed finding a new suspect would secure Porter's immediate release. This is what led them to All Story Simon.
So how did the investigation land on All Story Simon? I mean, the victims, Marilyn Green and Jerry Hillard, were murdered in 1982. Simon was a completely new name in 1999.
The sources detail that on January 29, 1999, so just weeks after Taylor's recantation, a woman named Inez Jackson came forward.
And who is she?
She was the estranged wife of All Story Simon. At the time, she was living up in Milwaukee, but Simon had ties to the Chicago area back in the 1980s.
And her statement provided this very specific alternative narrative.
Yeah.
What exactly did she claim Simon's involvement was?
Her claim was that Simon had killed Hillard, but it wasn't some random park shooting. She alleged it was in retaliation for skimming money from drug deals.
So that provided a clear motive that directly linked Simon to one of the victims.
Exactly. And she also made a crucial clarification, one that completely separated the two cases. She stated she had never met or even seen Anthony Porter.
So now we have a plausible alternative suspect with a plausible alternative motive backed up by a personal connection. Did she have anyone to corroborate this story?
She did. Her nephew, Walter Jackson, who was actually already incarcerated for first-degree murder at the time, he corroborated Inez's account.
And what did he add to the story?
Walter claimed that Simon fled to his apartment immediately after the shooting, seeking refuge. This narrative strengthened the connection between Simon and the crime, establishing a crucial physical link in the immediate aftermath.
So the Innocence Project team, they now have a recantation, a new suspect, a motive, and corroborating witness testimony. The next logical step was to confront All Story Simon himself, who was living in Milwaukee.
And this led to the most explosive and, as it turns out, the most damaging part of the entire case: the videotaped confession.
The documents show that Cellino and others from the investigative team, they contacted Simon in Milwaukee. The pressure on him must have been intense.
It was. And just 4 days after Inez Jackson came forward, this is on February 3rd, 1999, Simon was taken to the police, and he provided a confession to the crime, which was videotaped.
And the state's attorney's office, seeing a videotaped confession and the recantation of their star witness, they really had no choice but to act decisively.
The office of the Cook County State's Attorney immediately launched a new, very expedited investigation after they reviewed Simon's taped statement. The consequences for Anthony Porter were immediate and life-altering.
He was released on bail just 2 days later.
2 days later. After serving 17 years on death row, the state formally dropped all charges the following month, confirming his full exoneration.
At the time, it must have been seen as this massive victory for justice reform, for the power of investigative journalism. An innocent, intellectually disabled man who was hours from execution was free.
That's exactly how it was framed.
But the correction for Porter was really the beginning of the injustice for Simon.
Precisely. All-Story Simon was formally charged with the 2 murders. That same year, in September 1999, he pleaded guilty to 2 counts of second-degree murder and was sentenced to 37.5 years in prison.
And in the public eye, the case was closed. The truth was found. Justice was finally served.
The Innocence Movement celebrated a monumental win. It was their poster case.
But the sources make it explicitly clear that this corrected version of justice was, well, it was built on sand. We need to move it to part 3. The justice cycle fails, the recantations and fallout. Because the evidence that freed Porter and convicted Simon, it started to rapidly disintegrate just a few years later.
Yes, the foundation began to crack around 2005. The 2 essential witnesses whose testimony implicated Simon, his estranged wife, Inez Jackson, and her nephew, Walter Jackson, they both completely recanted their statements.
They both took it back.
Both of them.
And their reasons for recanting don't just undermine the case against Simon, they directly implicate the investigative tactics of the Medill Project. What were the specific motives they admitted to for fabricating the story?
They admitted to lying. And they said they did it to obtain financial assistance and legal leverage from Professor Protes and his team.
So it was a quid pro quo.
Essentially, yes. Inez Jackson wanted help freeing her son, Sonny Jackson, from prison. Walter Jackson, who was already serving a first-degree murder sentence, was seeking help for his own legal issues. The sources detailed that the Jacksons believed that implicating Simon was the fastest route to getting the Medill Project's resources focused on their incarcerated family members.
That kind of exchange fabricated testimony in return for potential legal and financial help. It just throws the entire process into ethical chaos. It suggests that Protest's team secured testimony of convenience, focused only on maiming Simon, rather than pursuing verifiable truth.
It does.
So if the 2 foundational witnesses against Simon were just fabricators motivated by self-interest,
Yeah.
the whole case against him falls apart.
It does, and it casts a very severe shadow over Simon's subsequent confession. I mean, if the initial narrative linking Simon to the crime was bought and paid for, or at least coerced through promises of assistance, then the confession itself becomes highly suspect.
And in fact, Simon did recant his confession.
He did. He claimed it was false and that he was pressured into it by Paul J. Sciolino and a second investigator.
This brings the interrogation methods of the Innocence Project team directly under the microscope. We need to go into detail about these coercion allegations because they are incredibly specific and highly problematic from a legal standpoint. What exactly did Simon claim they did to pressure him?
Simon's claims detail tactics that would be, without question, condemned if used by official law enforcement. First, he claimed the investigators, Sciolino and the other man, they misrepresented their status. They posed as city police officers.
Posed as cops. Okay, what else?
Second, and this is perhaps the most disturbing part, Simon claimed they showed him a videotape. But it was a videotape of an actor pretending to be a witness, directly implicating Simon in the crime.
An actor. They faked evidence.
That was his claim. The use of deceptive props and misrepresentation of authority. It's designed specifically to dismantle a suspect's certainty and their constitutional rights. The sources highlight that they were using methods designed to induce fear and guilt through completely manufactured evidence.
And on top of that, there were promises made, right?
Yes. Furthermore, Simon alleged the investigators promised him a much shorter prison sentence, implying he'd be back on the street quickly and even, bizarrely, a lucrative movie deal if he cooperated and confessed.
Movie deal.
A movie deal. So you have this combination of fear from the fake witness tape and financial enticement from the movie deal. It suggests an interrogation strategy tailored entirely to securing one outcome, a confession that would free Anthony Porter.
This is a textbook definition of coercion. It goes far beyond the ethical boundaries of journalism or even private investigation. It raises that critical question of constitutional due process. If police are prohibited from lying to a suspect about evidence, how could a quasi-official investigation linked to a major university employ these tactics?
That is the central conflict. And for their part, Protes and Cialino maintained their vigorous denial of any wrongdoing. They said Simon's claims of coercion were false. They publicly asserted their enduring belief that Simon was, in fact, the actual murderer of Green and Hillard, regardless of the controversy surrounding how his confession was obtained.
So they prioritized the outcome Porter's freedom over the integrity of the process.
That's certainly how their critics saw it. And the pressure on Northwestern University began to mount because of these allegations. It all culminated in a significant institutional response directed at Professor Protes.
What did the university do?
In 2011, Protes was suspended by Northwestern University. Now, the suspension wasn't directly for the Simon case. It was for falsifying evidence related to a subpoena in an unrelated wrongful conviction case that was being investigated by his team.
But that pattern of alleged manipulation, even in different case, it must have added enormous weight to the pre-existing concerns about his methods and his ethics.
It did. He resigned shortly thereafter.
So with the architect of the investigation now removed from his post, the legal system was forced to grapple with this awful reality that they had exchanged one wrongful conviction for a second one. And the spotlight shifted back to All-Story Simon.
Yes, this led to a year-long investigation by the Cook County State's attorney at the time, Anita Alvarez.
And what did her office find?
Alvarez's office spent a substantial amount of time systematically reviewing Simon's case, the original evidence, the recantations from the Jacksons, and the specific investigative tactics used by the Medill team. The investigation ultimately concluded that Simon's claims were credible.
And the conclusion was definitive.
It was. In October 2014, Anita Alvarez vacated the charges against Simon, ending his 37-and-a-half-year sentence. All-Story Simon was freed after having served 15 years for a crime the state now acknowledged he was coerced into confessing.
But the most important element of that 2014 exoneration was the official condemnation that Alvarez issued.
It was incredibly strong language. She publicly declared that the Medill Innocence Project's investigation involved, and I'm quoting here, a series of alarming tactics that were not only coercive and absolutely unacceptable by law enforcement standards, they were potentially in violation of Mr. Simon's constitutionally protected rights.
That language, coming from the chief prosecutor of Cook County, is not only rare, it's devastating. It confirms the fears of many critics that investigative journalism, when it takes on the mantle of advocacy, can be just as dangerous to due process as police misconduct.
It's an ethical failure on a massive scale.
It is. And the result is this profound, unresolved paradox. Anthony Porter, the intellectually disabled man, was freed. All-Story Simon, the second man convicted, was freed. And the double murder of Marilyn Green and Jerry Hillard remains open and officially unsolved. The justice cycle, in attempting this massive correction, failed catastrophically twice. And now the original crime has seemingly been abandoned amidst all the confusion.
A total mess.
Let's transition now to part 4, ramifications and final status, because this case fundamentally changed the legal landscape in Illinois, particularly regarding capital punishment.
It really did. The initial reaction from powerful city figures, though, was pretty predictable. Denial and a defense of the status quo. Richard M. Daley, who was the Cook County State Attorney during the original Porter prosecution and later became mayor of Chicago.
Right. He maintained that the original case was thorough and fiercely asserted no one railroads anyone.
Which you can understand politically why he would have to defend the integrity of his former office. And similarly, when Porter was first freed, the Illinois Governor George Ryan, he tried to frame the exoneration not as a failure, but as a success.
He did. He suggested it proved the system worked because its safety mechanisms had eventually freed the innocent man.
But that argument just couldn't hold up for very long.
No, it quickly lost credibility. The Porter case was not an isolated incident. The sources highlight that the Medill Project had previously helped exonerate other high-profile individuals on death row, most notably Rolando Cruz and Alejandro Hernandez, who had been wrongfully convicted in the horrific Gene Nicarico murder case.
So by the late 1990s, the public was seeing this pattern emerge. You have 3, 4, or more men freed from death row, one of whom came within 48 hours of execution. This created an overwhelming public and media consensus that the death penalty system in Illinois was fundamentally broken. It was just too error-prone. And this cumulative pressure became politically untenable. Governor Ryan, who is a conservative Republican, responded to this crisis by taking dramatic action in 2000. He initiated a moratorium on all executions in the state while he ordered a complete review of every capital case.
And that moratorium was really the beginning of the end for the death penalty in Illinois. The policy shift was huge, and the Porter case is consistently cited as the single most powerful driver for that change.
Without a doubt. 11 years later, in 2011, the state legislature passed a bill abolishing the use of the death penalty entirely, and Governor Pat Quinn signed it into law. The sources overwhelmingly agree that the near execution of an intellectually disabled man, Anthony Porter, provided the moral and political capital needed to overturn capital punishment in the state. So a huge systemic positive emerged from this ethical catastrophe.
But beyond the state policy, the fight continued in the courts through civil actions. And this led to even more perplexing results regarding Porter's guilt. He pursued justice through a lawsuit against the city of Chicago.
Yes, Porter sued the city for $24 million between 2003 and 2005, seeking damages for his wrongful conviction and 17 years served.
And this is where we see that crucial distinction between criminal and civil law play out. What was the outcome of that civil trial?
It was startling. The city refused to settle. And during the trial, the city's attorneys argue that Anthony Porter had, in fact, committed the killings.
They argue he was guilty, even after the charges were dropped.
They did. In civil court, they didn't need to prove it beyond a reasonable doubt, like in the criminal case. They just needed to convince the jury they weren't liable for the conviction. And the jury sided with the city. They found them not liable for damages.
So Anthony Porter walked away with absolutely nothing.
Not a penny.
That verdict is a true legal head-scratcher for anyone unfamiliar with the nuance of legal standards. You have the state's attorney dropping all charges, confirming his innocence in the eyes of the criminal law, yet a civil jury essentially affirms the city's argument that he did it.
It all comes down to the burden of proof. In criminal court, the state needs proof beyond a reasonable doubt to convict. But in the civil court, Porter had to prove by a preponderance of the evidence, meaning it was more likely than not, that the city's negligence caused his damages. The city used the jury's skepticism of Taylor's recantation and all the ambiguity of the original evidence to successfully argue that Porter just hadn't met his burden to prove his innocence sufficiently for a civil award.
Meanwhile, All-Story Simon, the man who replaced Porter in prison, also sought legal recourse based on the coercion he endured.
Yes, Simon first filed a post-conviction petition for relief back in 2006. In it, he specifically detailed Cialino's alleged deception, the use of the actor's video, the promise of a lighter sentence.
Right.
And this a crucial revelation that Cialino had recommended a specific defense counsel for Simon who turned out to be a professional colleague. This created a clear and very serious conflict of interest that compromised Simon's ability to receive due process.
That conflict of interest, that's the kind of detail that turns an ethical lapse into a legal violation. It suggests Simon was being steered toward conviction rather than protection.
And after his exoneration in 2014, Simon took direct legal action. He filed a federal civil rights lawsuit against Northwestern University's Innocence Project, arguing that they had used deception and coercion to secure a false confession, which resulted in him serving 15 years in prison.
And what was the resolution of that landmark lawsuit against the journalism program?
In November of 2018, Simon and Northwestern University reached an undisclosed settlement.
Undisclosed?
Yes. While the exact figure is private, the very existence of the settlement strongly suggests a recognition of the serious investigative flaws, the constitutional violations, and the ethical compromises he alleged against the team and the university.
It provided at least a financial measure of justice for the second wrongful conviction in this convoluted case. Finally, we should briefly summarize Anthony Porter's life after his release. After 17 years on death row and an exoneration that changed state history, you hope for a turnaround. But the sources, they paint a very painful picture.
They do. Porter's freedom was, tragically, short-lived and very turbulent. Less than 2 months after his 1999 release, he was charged with assaulting his teenage daughter and her mother.
Oh, no.
He later struggled with addiction and poverty, which led to a 2011 sentence of a year in jail for retail theft.
And what's his status now?
The source material confirms that Anthony Porter died of an opioid overdose on July 5, 2021. The system failed him twice. Once by convicting him and then again by releasing him into the world with seemingly insufficient support to navigate the immense trauma and the social challenges of freedom.
Looking at this material in its entirety, it's just a terrifying exploration of how good intentions can pave a road toward profound ethical compromise. The zeal to correct one massive injustice led directly to the creation of a second, while the initial victims of the crime, Marilyn Green and Jerry Hillard, have seen their case remain permanently unsolved and completely overshadowed by the subsequent investigative chaos.
We have documented a unique and a deeply cautionary case here. The pursuit of advocacy, when it's decoupled from the stringent requirements of constitutional investigation and ethical constraints, it resulted in one man being freed from the shadow of the execution chamber, yes, but another man losing 15 years of his life due to coercive tactics.
It really highlights the critical necessity of integrity in the search for truth.
It does. Whether you are wearing a police badge representing a defendant or carrying a journalist's notebook, the human cost is just staggering, not only for the wrongfully convicted, but for the public's confidence in the judicial process itself.
This story raises a critical question for you, the listener, to consider long after we conclude this analysis. In the urgent pursuit of correcting systemic injustice, how do we enforce the absolute line that protects the constitutional rights of every suspect, be they famous, obscure, guilty, or innocent? The integrity of the investigative methods, as this case so painfully illustrates, is inseparable from the justice we seek.
A powerful point to reflect on.
Thanks for listening.